Hi, my name is Andre Ong. I'm an accredited specialist in property law and a principal at Sharrock Pitman Legal. We frequently see disagreements between landlords and tenants of retail premises. One common disagreement relates to who is responsible for servicing and repairing an air conditioning system. So, whose responsibility is it? If you've already read our article, you'll see the answer is not straightforward. But let me give you a couple of tips. The first step is to check your lease. Is it a commercial lease or a retail lease? Then, what does the clause say? Does it have any carve-outs? It's common for a standard commercial lease to include the costs of both maintaining and repairing the landlord's installations as an outgoing, which means a tenant is responsible. And this may include capital works. If the lease is for retail premises, the Retail Leases Act contains additional protections and rights for the tenant. Generally, the Act says that the landlord is responsible for maintaining any landlord plant and equipment which the tenant is not entitled to take at the end of the lease. Even though the Act makes the landlord responsible for maintenance, the landlord can still pass on to the tenant such maintenance costs as an outgoing, excluding any capital costs. For example, the landlord can pass on servicing costs, but not the replacement of a compressor. My practical tips are: read your lease in detail. If your lease is retail, don't rely on the wording of the lease and make assumptions about who has responsibility for either the air conditioning or other maintenance, as the Act might override it. It also pays to make sure the landlord's disclosure statement is detailed and sets out all estimated outgoings for maintenance and servicing. If you need any help, I can assist you. It would be great to hear from you. We're on your side.